Hey all, back this week to talk with you about parental relocation. So this statute is kind of a tricky one. It's 61-13-001, and due to the way society is today, we have a lot of families that both parents don't necessarily remain in the same state. Also here in Tampa, we've got the Air Force Base, so there's a lot of opportunity for one of the parents, either of a divorce or with a child born out of wedlock, to have to relocate. So Florida Statute 61-13-001 deals with parental relocation. So it doesn't necessarily just have to be the child of a marriage. It can be a child born out of wedlock. But in a situation where one of the parents is seeking to relocate a distance greater than 50 miles and for a period of time in excess of 60 days, strict compliance with this statute is necessary. And there's really two different ways that can be done. One is by the agreement of the parties. So what we have there is a situation where the parents agree that one of the parents is going to relocate that distance for a period of time in excess of 60 days. And this is not really meant for people just going on long trips or visiting family. This is where someone is actually relocating the residence. One of the things that is kind of confusing to people is it's not 50 miles drive time. It's 50 miles as the crow flies. So it may be a longer drive, but in a straight line from where they had previously lived at the time that either the petition was sought or that a prior order was entered. If it's greater than 50 miles straight line, then you need to comply with this statute. So the first way is by agreement of the parties, and basically the statute requires the parents to enter a stipulation that they agree to the relocation, discussing what the time sharing will be between the parents once that parent is relocated, and addressing any of the other specifics necessary under the statute. And then that agreement would have to be ratified by the court. So that's kind of the easier way. The more difficult way is where a parent is objecting to the relocation. In that situation, the party seeking a relocation needs to file a petition with the court. And before I even go any further, this statute is not unique, but kind of one of the more rigid statutes that we have in Florida family law, because I've seen so many petitions for relocation fail, not because they were sought in good faith or not sought in good faith, but fail because they didn't comply with the strict mandates of the statute. So that's of the utmost importance with these relocation cases. You need to have all of the information in there. There's certain disclaimers that need to be included in the petition. And if you don't, hit each of those criteria, the petition can be denied on its face. So it's important that you have someone who knows what they're doing in filing these relocation statutes. And in filing the relocation statute, you have to establish that you're doing it in good faith. You have to give the basis for why you're relocating. You have to give the information as to where you're relocating, the address, the telephone number. If it's based on a job opportunity, you need to include documentary evidence as to what the job is. You need to allege why this is a better situation than this parent and the child remaining in the jurisdiction of this court, or at least within that 50-mile time range. So that's the petitioning party. And then the party who's objecting to it, they also need to file a written objection. It needs to be verified, which means it needs to be signed under oath, penalty of perjury, or notarized. Again, with the objecting party, if they don't meet the strict criteria of the statute, you can lose for that reason as well. So again, knowing the statute backward and forward, very, very important. Now, once the petition, the objection is filed, these cases are given priority for an expedited hearing by the court. Usually that's within 30 days. That's not the final hearing, but oftentimes these relocations are needing to happen quickly, either because there's a deadline to accept the job offer, or maybe school is starting back and there needs to be some determination made as to where this child or children are going to be going to school. So the court will give an expedited hearing for a temporary order, and that's usually within 30 days. Just like in the time-sharing subsection of Chapter 61, in this statute 61-13-001, there's a list of criteria that the court's going to consider as to whether or not they're going to grant a relocation. And before I hit on those criteria, I just wanted to mention one of the most difficult parts of the relocation statute and as a basis for a cause of action is there's really very little middle ground for parties to agree on. You know, with a divorce or a post-judgment modification or a paternity action, sometimes people are fighting over how much time sharing they're going to get, so they can agree on a middle ground. Or maybe they're fighting about how much child support or alimony or whatever the issue might be. There's a middle ground. But with these relocation cases, there's almost no middle ground. It's either the relocation is going to be granted or it's going to be denied. So it's very difficult for parties to meet in the middle on these cases and come up with some sort of settlement out of court. So these relocation cases often go to trial more often than other causes of action under this statute. And it's also difficult for the judges because there's usually a clear winner and loser in the judge's ruling, whereas in the other areas they can kind of, you know, give each side a little bit of what they're looking for. So in any event, the factors that the court considers, just some of them, is the quality of the relationship between each parent and the child, the age of the child, the developmental maturity of the child, and how this relocation might impact the child. The feasibility of preserving the relationship between the child and the non-relocating party. You know, these are just some of the factors. There's more factors than that, but it's similar in some ways to the 6113 and the considerations that the court's making in determining who a primary time-sharing parent is. So in any event, a lot of military families this comes up with, a lot of corporate families who might be taking jobs in other states or in other counties in excess of 50 miles. We see these coming through our door a lot more frequently these days, and can't stress the importance of really knowing the statute well, making sure your pleadings follow the statute, and knowing what the court is looking to hear. There's a couple of cases out there that the courts rely heavily on and are going to want to know whether or not you're falling within those rulings when they're making their determination. So hopefully this has helped. If you have any other questions on parental relocation, as I mentioned in our previous videos, you can check us out on Facebook, Instagram, go to our website. You can call us, email me, whichever you like, and I'm happy to discuss it with you further. Thank you again.